Hello, my name is David Healy with Appleby Healy, Attorneys at Law. Today I'm joined with Attorney Brian Barry and, of course, David Appleby, and this is the 2023 Client Care Program video. So today we're going to talk about trust administration. If you go to one of our workshops, that is the topic we're going to be talking about, and this video is going to be a recap of that workshop. So if you cannot make it to a workshop, you're going to hear all the same information here today. And we're going to start out with Mr. Appleby. David, why does anybody need to administer a trust?
Well, I think when somebody dies, there are any number of things that have to be done. Unfortunately, there's very few people, including most non-estate planning or trust lawyers, don't really know all those things that have to happen. And I would say this is kind of an evolving area in the law, in that things that didn't exist 5 or 10 years ago in terms of court cases or additional legislation. We didn't worry about this, frankly, so much, let's say 10 years ago. But today, with all the additional rules for compliance and actions that have to be taken, it requires somebody that can put in some time and energy, and hopefully, of course, that's what we can do to help you in terms of the trust administration. But for instance, when somebody passes, I think people think that, well, we can just immediately distribute the assets. Well, that really isn't true, because the beneficiaries get the assets, but subject to the claims of creditors. So one of the early things we have to do is be sure that we get all the bills paid. And I'm sometimes amused when clients come in and they seem to believe that if somebody dies, they don't have to pay the bills, they don't have to pay the debts. And of course, you can't die to get out of paying your bills. So this is a growing area of the law, and one I think that is a good topic for us to discuss today. Just as a reminder to you, there are, if you will, 3 types of estates. There is probate, which does require that we go to court. When we do that, it may not be as bad as what some people think, but there are those expenses related to probate and the time and energy that goes into a court proceeding. On the other hand, type number 2, if you have everything in a trust, or payable to the trust at your death, then we don't have the probate issue. Okay? Both of those have some positive tax implications, but the trust avoids the probate. So to kind of reinforce what was explained to you back when we did your trust, of course, one of the principal things is for tax advantages and then also to avoid the probate. There's a third type of way to kind of pass assets at your death. It's under the Missouri Non-Probate Transfer Act, and that's the POD and TOD transfers, something that typically we don't recommend unless it's to fund the trust. And the reason that we say that is, although the title is non-probate transfers, in fact, very often leads to probate. So we don't suggest that. And the way it leads to probate is the beneficiary you name dies before you, or the beneficiary you name is a minor child or has become disabled or incapacitated in some manner, in which case we have to do probate. And then 2, sadly, sometimes people leave 2 or 3 beneficiaries with these non-probate transfer designations, and then when they don't get along after your death, you won't be around to know this, but then they don't get along, and now we're in a full-blown lawsuit in the circuit court to get that resolved. So just bear in mind as we talk, there are 3 ways to do this. Obviously, you wouldn't be seeing this if you hadn't done a trust, and I would just assure you here that that probably is and remains the best way to handle your estate.
Now, David, one of the reasons that we want to help clients with trust administration is actually to protect the trustee, right?
Yes, and I think this is, by the way, a misconception sometime too that people have, that we represent all the beneficiaries. Well, of course we want to protect everybody, the assets, but when you come to us for trust administration, we're there to hold your hand and guide you through, and that's kind of the rules and regulations and statutes and the things we want to talk about today, so that if your spouse should pass, for instance, or if your parent should pass or whoever, and you become the trustee, so you have some feel for exactly what you need to do.
Now, Brian, how's trust administration different than probate administration?
Well, the short answer is one place you don't want to be, and the other is most preferable. I have yet to have an estate plan client come in and say that one of the reasons they were doing an estate plan was not because they wanted to avoid probate. And I will often tell them that we all know very lovely people who work in the probate courts around here, but they would all, if they were in the room with us, tell you to stay out of their world if you possibly can. And the reason for that is unlike probate courts, administering a trust is private. It's done at the family's own pace. You don't have a court, I call it Mother May I, going into court and get permission for every move you make. That's where the expense racks up in probate court, is you can't make a move almost without filing a motion in probate court and then going over and having that motion heard. That's just not the case with trust administration. It happens at the family's own pace, and it's not so time consuming, and because of that, less expensive. The expense in probate court comes from just how long it takes to do that.
Now, David, you mentioned non-probate transfers, and I want to talk about that for just a minute, and how that differs from trust administration. And David, your points were all very salient. Reasons that we don't advise clients typically to rely on non-probate transfers. Many of you have maybe heard me talk before how I'm going to anticipate a very slow news day in Los Angeles. The LA Times ran a front page story on the false security of non-probate transfers. And the reason that we talk about this being false security is all the problems that we get to clean up on the lawyer end of these non-probate transfers when they are not going to a trust. So beyond the incapacity, which could be a minor child, obviously a 12-year-old cannot take title to real estate or manage it. So we have that issue, and of course we have disability. One of the biggest issues that we deal with is creditors. And when you leave, for instance, your real estate with a beneficiary deed to your children, and say we have 3 children, and one of their spouses whose marital rights attach has a creditor, everybody gets to deal with that in-law's creditor. So that's a big difference between administering a trust versus administering a non-probate transfer. The non-probate transfers all happen by operation of law immediately upon death. There's no breaks. There's nothing we can do to fix it. We have to go to court to get it straightened out typically. And with the trust, we have all these built-in breaks where we can slow the process down, we can evaluate, we can shield assets from creditors, we can negotiate, make sure that the in-laws creditors don't come into the estate. So it's a vast difference between administering an asset through a trust versus just having it foisted upon the kids with a non-probate transfer. Now, David, when somebody comes in and says, my parents have died or a loved one and I'm the nominated successor trustee, what's that first meeting look like?
Well, let me even back up a little from that and say that the successor trustee needs to call us and schedule an appointment as quickly as possible when somebody passes. I don't frankly like to see people before the funeral, although sometimes that's necessary, but you need to come see us as quickly as possible, because if you do that, you're less likely to do the wrong thing or fail to do something you're supposed to do. So like I say, I can't really underscore that enough. I just took in a case this week, and when we started going through the worksheet about what needed to be done, and I explained that these assets are subject to claims of creditors, like I mentioned before, and they said, oh, so we shouldn't have already been giving property away. They distributed quite a bit of cash and other personal property, and as I explained to him, that puts a successor trustee in a position to be personally liable for any of those assets that are distributed in the event a creditor comes along. So the first thing to do is schedule an appointment and come in. At that point, we go through a worksheet. We confirm the assets, we confirm what creditors we can, but we give the successor trustee kind of a homework assignment. We're going to need to see this and this and this in order to help you administer this correctly. One of the first things we do then on our homework list is get you a federal employer ID number. That's really important because for you to open up a trust account in the name of the successor trustee, you're going to have that for the bank. if there's real estate and we're going to sell that real estate, we'll need to provide that to the closing company. So that's one of the very first things we do. We also explain about securing the property. It's not unusual that sometimes, frankly, family members, but others might come into the home and take assets. I think we're all increasingly concerned about who has firearms, but firearms particularly, and other valuables, jewelry and other things, they need to be secured. And then we need you or your successor trustee to sign an acceptance saying that we've gone over all these rules and regulations and court cases. We tell you what you need to know to properly administer that and not make any mistakes. So that first meeting is usually just going through a worksheet, see what needs to be done for us and what needs to be done by you.
And David, if we could talk about that acceptance of trustee for a second, because sometimes I get questions about, well, why do I need this? It's true, actually, that trust nominates somebody to be a trustee. Right. They've not accepted that until they sign a piece of paper, and somebody like a diligent title company, like Legal Land Title, they may ask for that to make sure you're actually serving, it's not the next person. Absolutely,
and often, of course, kind of along with that, we need to get either resignations or proof of death of any other successor trustee that would have served ahead of time. So it kind of causes us to get all the information we need just so we can show that to others.
Now, Brian, in some states, I'm going to pick on California because that's easy.
They're an easy target.
They're easy. They have a very rigid, very involved statutory framework of things a trustee must do, and it's quite a long checklist. What statutory requirements exist in Missouri that a trustee shall do as opposed to may do?
Well, certainly it's not at a level of California or some other states, but it is governed by Chapter 456, the Missouri Revised Statutes. One of the very first things that you're required to do, and it does make sense, is to protect the interests of the beneficiaries, is to let them know that they are beneficiaries of a trust, and that the settlors, the people who created the trust, are now gone, and that they are, in case they didn't know, that they are named as a beneficiary of the trust. They're also to be provided a copy of the trust and any amendments that have been made to it. So those rights are protected.
Okay. Now, after we get past the statutory things, there's typically some other things that we can do, and that's typically a meeting that we're going to have with that successor trustee, make it really clear kind of things that we may want to provide to them, and a lot of times we do. That would include preparing things like trust certificates to facilitate real estate transactions or transactions with financial securities firms. And typically we are going to offer to prepare an inventory. And it's kind of a little bit of common sense. If it's a piece of real estate and a checking account, that may not be necessary, but for a more complicated estate, and particularly an estate that has more beneficiaries, an inventory is a nice instrument to prepare where we list out all of the assets so everybody understands what the trustee is in charge of and kind of what the trustee is going to be managing during the period of while they're kind of administering the estate before they get to the end of the road. And discussing administering the estate, David, once we get past this initial meeting and we kind of get started, we have our tax ID and our acceptance and maybe a trust certificate, what's a trustee do?
Well, initially, of course, they need to garner the assets. They need to be sure that they've got control of everything. Sometimes that's harder than you think. Sometimes the trustee, successor trustee, I should say, has not been involved in their parents' or their uncle's affairs. And so it's a little bit harder to figure that out. It might take a little bit more time. But the first thing is to be sure we know what all the assets are. Sometimes we prepare a formal inventory, not always, but generally speaking, if you have several beneficiaries, then that's a pretty good idea to do. And then, once we've got all the assets, we know what we have, the trustee needs to safeguard those assets and then liquidate them if that's what everybody wants. Now, there is such a thing as distributions in kind. So there is another misunderstanding, I think, out there sometimes, or misconception, that if it's in a trust or a probate estate, everything has to be sold and the money divided equally. That's not correct. It is possible to divide things in kind. Typically, though of course it's hard to take 80 acres and divide it 3 ways equally,
Who gets the sinkhole, right?
Right.
Yeah.
And so typically what we do in those circumstances, if we want to divide in kind, we have all those beneficiaries and the trustee enter into something called a settlement agreement. So we're adjusting a little bit. So if we have 120 acres and they each want 40, they don't have to take a 1/3 undivided interest in 120 acres. They can actually each get 40 acres. So, but in any event, we have to safeguard, and then if we need to pay the bills, again, remember we have to pay the creditors, and then we're ready to distribute. And then when we actually get to the distribution part of administering the trust, we would account to all the beneficiaries, and that's one of the obligations. We may talk on that later, but we have to account. We have to show everything that came in, everything that went out, provide that to them, along with their check for the distribution, the money they're going to receive. So it's an ongoing process, and it takes months, and I think we will talk about that, or maybe we
Let's talk
circle
about that.
back.
So Brian talked about the shall things, and of course there's a lot of other statutes of things a trustee may do. One of those is a notice to creditors. Correct?
That's right. It's not technically required by 456, but it's allowed for, and an incredibly good idea. The reason for that you would send notice to, or publish notice to creditors is because you can shorten the window in which they have to file a claim, which would otherwise be 1 year. You can bring that back down to 180 days. And those are for unknown creditors. And presumably the trustee is going to be taking care of those creditors that can reasonably be known whenever they want to. But that 6-month window is half of what it would ordinarily be if you don't do that notice to creditors. So there's really no good reason not to do that. And while you're doing that, you can be dealing with things like tax issues. There are some tax returns that may or may not need to be filed. Form 706 if there's an estate tax issue, or generation skipping tax that applies. The person who's passed away doesn't get away with not filing their last 1040.
So the IRS wants to be paid?
The IRS has their nose in everything, including estate planning, and there is that one final 1040 that's going to need to be filed, even if it's a partial year for the year during which the person died. And then you may or may not have to, as a trustee, deal with the 1041 tax return, which is a tax return filed by the trust estate. There are triggers for that needing to be filed. If the estate earns more than $600 in the given tax year, then that would need to be filed. If real estate is transferred, clearly that's going to generate more than $600. So those are all things. There are things you can be doing while you're waiting that 6 months for the unknown creditors to come out of the woodwork that you didn't know about. But it's an incredibly good idea to do that.
And David, that 6-month window, fair to say that's probably the majority of our estates as far as trust administration. We're kind of working our way down. What happens at the end of that 6 months?
Well, of course, then we can make distribution. And there's a couple of ways, or a couple of things to know about the distribution. I already mentioned having the settlement, or having and sending that with the check, so people know exactly what they're going to receive. But very often we can just distribute free from the trust. So you get the check, you have a deed transferring the property to you. If you're receiving personal property, you get a bill of sale from the successor trustee. So that's just free from the trust, and then the trust terminates. And the vast majority of trusts we draw, I think, are premised on the fact that as soon as possible after your death, we liquidate, we distribute, so everybody gets their money as quickly as possible, going back to why it's a wise thing, as Brian says, to publish. Now, sometimes that's not possible, because sometimes we have sub-trusts, if you will, for certain beneficiaries. And Dave and I were in a meeting earlier today where this came up about what's called special needs trusts. There seems to be an increase in special needs trust. Special needs trust is where you have some beneficiary, typically a family member, who has some disability. They're disabled or incapacitated, and perhaps even a mental illness, not just limited to physical, and they really can't manage their share. So that share is then held in a special needs trust, particularly if that particular beneficiary is drawing any state or federal benefits. So with the special needs trust, we can sometimes be sure that those assets then will be available to the other beneficiaries at the death of the beneficiary with a special need. Now, it's not necessarily a special needs trust. I hear them called education trusts or medical trusts, but very often one of the issues is that the beneficiary is younger than what you say you would want to you'd want them to be in order to make a distribution. So that's the clause in your trust where you say nothing would be distributed to anybody under 25 or 28 or 30 or 50. If you say 50, I would probably argue with you and say, you know, if for most people, if they're not going to grow up by 30, they're not going to be grown up at 50. But the law in Missouri is that you're an adult at 18. The simple fact is, for most people, their children, their grandchildren, their nieces and nephews that fall in that category really are not financially proficient, if you will. They don't really have the life experience or the money management experience to handle particularly any large sums of money or real estate. So we can give things to people outright, and then there may be some special circumstances in your trust where we would hold that for others until they get to be a certain age or until their death.
And some of the trusts that our clients have are actually set up where the beneficiaries get to make that decision themselves. Essentially, it's set up with a lifetime spendthrift trust, but they have the power to withdraw the principal out. So some of you have heard that we talk about this concept that the kids are in charge, kind of captain of their own ship here. So if we have 3 kids and they're set up with lifetime trust, they can elect to keep it in trust, which of course has certain drawbacks. They have to file tax returns and have an accounting and things of that nature. But the upside to that is it's somewhat protected while it's in that trust. It's not a marital asset, and they would have some protections if they were to get themselves into financial trouble of some sort. Closing here, David, 99 years.
Yeah.
And you've been here for 98 of them.
Almost. Okay, yes, I am still here. I get asked frequently, am I going to retire or when I'm going to retire? And I think that really comes when health fails or Dave runs me off, but I'm still here into the future. But what I did want to share with you, yes, our law firm is 99 years old. We were established in 1924. Many of you have heard our tagline, local lawyers helping local people, since 1924. In 1924, by the way, the firm was basically, it was on the square in Ozark, as it remains, but the firm mostly serviced people in middle and eastern Christian County. Today, I'm proud to tell you, 99 years later, we basically do trust work, probate work in the entire Southwest Missouri. So we're really a regional law firm now. Our firm has expanded in lots of things, but I would just say this: we appreciate so much the loyalty that our clients all around Southwest Missouri show us. In many cases, even just going back to my dad, we've represented 3 and 4 generations of people in this area, and we appreciate your business very much. And we look forward to celebrating our 100th year. And I don't think we've got all the plans for that celebration yet, but I know we plan to do some special things for our clients. And again, I just want to say thanks for all that over the last 99 plus years. And we'll look forward to seeing you, if not this year, certainly in 2024.
It's pretty exciting. Brian, do you have anything you want to add?
Oh, just that I was just sitting here listening to David talk about the firm's history and how rich it is, and I've been here a little over a year and a half, and that's one of the things that was very attractive to coming here, is the opportunity to graft myself into that sort of history. That's not every firm can say that. So, and it's every day most days I get to meet a client who is referred to us by someone who's a part of that history. Administering the trusts that go back to Bob Ingold when he was drafting those. So it's a pleasure to be a part of that history.
Well, we certainly appreciate our clients. We want you to call us if you ever need anything. The 3 of us don't handle traffic tickets or anything like that. But if you ever need any legal help, please give us a call. We will send you in the right direction. And again, we're going to have a series of workshops this year. They're going to be about trust administration. It's going to cover in the workshops essentially what we've talked about here today, but feel free to come out. We'd love to see you.